Sonam Wangchuk खुश हुआ or not yet. See, he lives for Ladakh, though he vibes with the entire humanity, being a scientist, environmentalist. The point is, has he become happy because a permanent bench of the J&K High Court has been sanctioned for Ladakh? What's the constitutional process of all this? The statutory process of all this? A High Court? Who sets up a High Court? Who decides the jurisdiction of the High Court? What is a common High Court? What are permanent benches like the one that's been sanctioned for Ladakh yesterday? What are circuit benches? We'll see all this with the help of States Reorganization Act, with the help of Punjab and Haryana Reorganization Act 1966, with the help of Andhra Pradesh Reorganization Act 2014, and also J&K Reorganization Act 2019. So what are we going to see here? We will see the Constitution, Article 214, Article 231, Article 230, Article 241. We'll see all these 4 articles. We'll see, as I told you, the States Reorganization Act 1956 and other reorganization acts. And we'll also see outside the Constitution and the acts, the statutes. So let's consolidate the entire thing. Let's get the basics first. All these are basics. So Ladakh was sharing a high court with Jammu and Kashmir. Both the union territories were carved out from a single state in 2019 through the J&K Reorganization Act. You know, people from Leh were going to Jammu. People from Kargil were going to Srinagar. Kargil to Srinagar is about 500 kilometers. And here it is about 220 kilometers. People who are trekking all this way. And the money it takes, the time it takes, the inconvenience, the stress, that is violative of rule of law actually. Because if the law doesn't reach you, then what's the function of the law? So yes, there have been demands about greater autonomy for Ladakh, and one of the demands is that you create a permanent bench here. You know, J&K High Court has 2 divisions. There is no other High Court in the country that has divisions. They are not benches. They are not principal seat, permanent bench, principal seat, circuit bench. No. The principal seat itself is cut into 2 halves. One half, Jammu. The other half, Kashmir. So, there are 2 divisions like nowhere else in the country. Now, Ladakh wanted autonomy. Autonomy cannot be by an independent high court because you see, Goa doesn't have one. Arunachal doesn't have. Mizoram doesn't have. Nagaland doesn't have. So, Punjab doesn't have an independent high court. Haryana doesn't have an independent. They share one. And Ladakh doesn't have so much of demand for an independent high court setup. And therefore, independent high court is ruled out. But a permanent bench is in order because you are saving so much of money, time and stress, and you're giving so much of convenience for the people of Ladakh. That's how one presumes it will gladden the heart of not just Sonam Wangchuk, but the entire people of Ladakh. Now let's get to the constitutional side of it. Though Ladakh permanent bench has nothing to do with the constitution. It is only a statute. J&K Reorganization Act 2019 says that the government of India can set up a permanent bench. That is done by how? The president gives an order setting it up. That is how it is set up. There is no constitution. Constitution doesn't talk of benches. It only talks about high courts. It doesn't talk of permanent bench. Now, what is Article 214? We're coming to the high courts. 214 says there shall be a high court for each state. But then you will see that there are 28 states in India and there are only 25 high courts in India. Article 214 is departed from. Yes, of course, that power is given to the Parliament under Article 231. 231 says that Parliament can set up a common high court for 2 or more states, and that may include 1 or more union territories also. So 2 or more states and UTs, Parliament can set up by a simple law, ordinary law, simple majority, either house. So that is how the Article 214 is departed from in Article 231. That is about the states. There can be an independent high court, which is a norm. There can be common high court, which is an exception, Article 231. But what about the UTs? Article 241 gives Parliament the power to set up a union territory. Article 200 set up a high court for union territories. Article 241. Article 230, it says that the jurisdiction of a high court can include a UT or exclude a UT. For example, Kerala High Court takes care of Lakshadweep, the union territory. Madras High Court takes care of Puducherry. And the Bombay High Court takes care of Dadra Nagar Haveli and the Daman Diu. So extension of the jurisdiction of an existing high court to a UT is what is allowed under Article 230. Setting up an independent high court is the power given to the Parliament under Article 241. So 214, the general rule for the states that there shall be a high court for every state. 231, departure from it for common high court. 241, Parliament can establish an independent high court for a UT that deals with the UTs. For example, there is only one UT with an independent high court, that is the Delhi. So under Article 241, Parliament exercised its power to set up a high court for Delhi. Under Article 230, Parliament exercised its power to extend the jurisdiction of an existing high court to a UT. It can as much as extend as also it can exclude. Exclude it can, it hasn't, but it can. So 214, general for every state. 231, departure. 241, setting up an independent high court for a UT. 230, extension of the jurisdiction of an existing high court of a state to a UT. For example, I have given you Puducherry, Lakshadweep and Dadra Nagar Haveli and Daman and Diu. So this is the constitutional side of it. Now what about the statute? I've already told you, when states were reorganized, you had to give consequential power to the Parliament to set up a common high court and related aspects. So under the States Reorganization Act, under the Punjab and Haryana Reorganization Act, under the creation of Goa, the state 1987 Act, under the Jammu Kashmir in 2019 Reorganization Act, before that in 2014 Andhra Pradesh Reorganization. In all these reorganization acts, the power is given to the Parliament to either establish a common high court, the power it already has under Article 231, the establishment of a common high court and setting up a permanent bench. So we already have seen for Ladakh, the power for the union government to set up a permanent bench in Leh is given under the J&K Reorganization Act. Similarly, a common high court, etc. under the Punjab and Haryana Reorganization Act. So setting up the permanent bench is outside the constitution, inside a statute, like all the acts we have just now listed. That is how it takes place, but you must remember that Parliament doesn't come into the picture. It is only the initiative of the High Court. High Court proposes. After that, it goes to the Union Government. Union Ministry of Law and Justice peruses it. And then the consultation is with the CJI. The consultation is concurrence. Whatever the CJI says is mandatory. It has to be followed by the Union Government. And after everything is worked out, it is the presidential order that eventually sets it up. And of course, like for every other important decision, Union Cabinet calls the shots here. And so you have seen in every news report that it is the Union Cabinet that decided to sanction a permanent bench for Ladakh, headquartered in Leh, and they don't have to travel to Jammu, they don't have to travel to Srinagar, and so a lot of convenience for them. That is about the permanent bench. What about the circuit bench? See, justice is very crucial for people. Courts have to be close to them. Rule of law demands that courts have to be close and inexpensive, and quick justice must be rendered. So the point is, there is, let us say, Madras High Court. Madras is a fairly large state. And for the High Court to reach everyone, it should have not just the headquarters, it can have a circuit bench. For example, in Madurai. In northwest Bengal, Jalpaiguri, there is a circuit bench. In Madurai, there is circuit bench. In Port Blair, Andaman Nicobar, there is a circuit bench of the Calcutta High Court. So the point is, what is a circuit bench? The full court, the High Court, the full court decides, let's have a circuit bench. It is a temporary bench, temporary in the sense it doesn't work round the year. It works for a few months, and the honorable judges of the High Court go there and handle the cases and come back. That's only for a limited part of the year. That is a circuit bench, and that has nothing to do with the act at all. It is the initiative of the High Court. Full court takes the decision, the proposal goes to the union government may endorse it. After that, the union government, not the president, union government gazettes it, and that is how the circuit bench is set up. I've already told you there are 3 circuit benches that I can recall for you instantly. The latest being in Jalpaiguri, North Bengal. And before that you had Madurai. Madurai was about 20 years back in 2004. And well before that inception of the constitution, you had in Port Blair the circuit bench covered by the Calcutta High Court. So circuit bench is the least complicated of them. Ahead, if you escalate in procedural terms, you will get the permanent bench, and beyond that, of course, is the Constitution. 214, 231, 241, 230. That is how you see, when you have in Article 214, every state shall have a High Court. The word is state. So UTs are handled separately, 241 and 230. So this is the Constitution, the statute, and outside. We have seen how Ladakhi people must be quite relieved about the proximity of the High Court to them, and they don't have so much of anxiety about getting justice. This is the statute and the current event. Let's see slide by slide, map by map. Here is Sonam Wangchuk, happy as ever, happier now. So a High Court for Ladakh. I've told you the whole process under the J&K Reorganization Act. There is room in the J&K Reorganization Act for setting up a permanent bench. And so residents, they don't have to travel Kargil to Srinagar and Leh to Jammu. They don't have to travel. The decision was taken earlier this week. By the cabinet, all important decisions of governance are taken by the Union Cabinet. You don't have to mention that as a part of the procedure. You have to mention the act. You also have to mention the presidential order. President comes into the picture here only for permanent bench. As far as 241, 231, 230 are concerned, surely a law made by Parliament will have to end up on the table of the President, whose signature makes it an act. That's okay. That goes without saying. But explicitly mentioning a presidential order, you find only in the Reorganization Acts for the setting up of the permanent benches. So what changes? Access to justice, faster, Lower cost, lower effort, equal footing. Equal footing. Means there is a sense that both the UTs are equal. Though there is only permanent bench here, the High Court resides 50-50 in Srinagar and Jammu. But permanent bench is as good as having the High Court next door. Why not a new High Court? See, there is no demand. You have to have a full High Court with that much of strength and expenditure, buildings and other infrastructure, housing and so on. Where is the demand in Kargil? You don't have demand in Goa, Arunachal, Mizoram, Nagaland. You don't have demand. So, you are talking about Ladakh having an independent High Court? That is virtually ruled out unless as a status symbol and political assertion, which should not bother us. Constitutional context, I told you 214, 231, 241 and of course 230 also. If you are talking about 230, 241 is the general parliamentary power over the UT High Court. Set up a High Court like you've done for Delhi in 1966. And you want to extend the jurisdiction of an existing High Court to a UT, then of course Article 230 kicks in. I gave you the examples of Kerala, Bombay High Court and the Madras High Court regarding their reach towards the respective union territories. Article 230 here. 230 and 241, they are linked. 231 and 214, they are linked. Now, constitutional basis of High Courts, again let's revise. There shall be. This is the general norm and that applies to 25 states. Where there is no local demand, why should you have a High Court? Instead, logistics, etc. demands that you extend the jurisdiction of a nearby High Court to that state or UT. 3 states I have told you. 4 states, Goa, Mizoram, Arunachal Pradesh, Nagaland, they don't have a High Court. And the 3 northeastern states are covered by Guwahati High Court, situated in Assam. And Goa, of course, is covered by the Bombay High Court. Goa is covered by the Bombay High Court with a permanent bench. 231, that is. 231 connects to 214. 241 connects to 230. We have seen. Both relate to the UTs. Role of Parliament. Parliament comes into the picture 231, 241, 230. And it also comes into picture in making the Reorganization Acts. 1956 States Reorganization Act. Then when you have Punjab, Haryana, Telangana, J&K, Goa, all these laws are made by the Parliament. So Parliament sets up a High Court, sets up a common High Court and establishes a High Court for a UT or extends the jurisdiction of an existing High Court to a UT. All these are done by the Parliament. So tomorrow there can be a simple question. Now that Ladakh is in news, now that Ladakh is in headlines, there can be a simple question for sure in the prelims. Because High Court may relate to a state, but all the functions are that of the Parliament or President. You know, they are the ones who decide about whether you have a High Court or not, and whether you share a High Court or otherwise, and also the Reorganization Acts and the consequential position of a permanent bench. So Parliament and High Court, a very good main question and prelim question. Permanent bench, prelim question, and presidential power in the establishment of a permanent bench. You know, the choices can be a permanent bench of a High Court, as we have seen being established in Leh, in Ladakh. The procedure followed is the following. Permanent bench has a place in the Constitution. Permanent bench is set up by Parliament. Permanent bench is, etc., etc. Every multiple you will have in your question, you will see in what we have discussed. You don't have to step out at all. I have purposefully made it exhaustive so that it is a one-stop place for you to cover everything about Ladakh related High Court stuff. So role of Parliament, I have told you, 14 is the general rule, there is no Parliament there. 31, 41, 30, all three relate to Parliament. Permanent benches, directly Parliament doesn't set up. In a Reorganization Act, there is created room for permanent benches, the act being made by the Parliament. But setting up the permanent bench, Parliament has nothing to do with it at all, except that the mother law, which makes room for the permanent bench, the Reorganization Acts, they are made by the Parliament. That is it. Nothing more about Parliament being linked with the permanent benches. Next, Parliament and Union Territory. I have told you as far as the UTs are concerned, because Article 214 is about states. So you need to have a separate constitutional provision for UTs. That you find in 241, setting up a High Court, for example, Delhi. That you find in Article 230 also. Extension of the jurisdiction of an existing High Court to a UT. And the examples are, you have Kerala, Madras and Bombay. And I have discussed it already about half a dozen times today itself. 241 and 230. These are the two articles related to, once again, a very good prelim question. And who knows, a very good main question also. Conventional question. All you have to do is set aside half an hour or 1 hour or 90 minutes and you are the champion. Next. Common High Court. Common High Court is, I have already told you, under Article 231, Parliament has the power to set up a Common High Court. For example, Guwahati covers 4 states. Bombay covers 2 states. Punjab, Haryana, it covers 2 states and a UT. They are all common high courts. The power coming to the Parliament under the Article 231. Common High Court. Permanent bench versus circuit. Permanent is a part of the Reorganization Act. Circuit, no. Permanent, the presidential order is important. Circuit, no. Permanent works round a year like the principal seat. Circuit, only for a limited period in a year. These are the 3 important differences between the two. Both of them make justice accessible, inexpensive, and give relief to the people who have access to these benches. Here it is, Jalpaiguri. I told you the latest circuit bench. Before that, Madurai. And of course, from the time established 1950, that is Port Blair. All 3 are circuit benches. Whose decision is it? Local High Court. Full court tells the CJ, sir, let's have one. Proposal goes to the Union Government, Union Ministry of Law and Justice. They vet it. After that goes to the Cabinet, of course. And here nobody else comes into the picture. CJI will obviously come into the picture. He'll be consulted. President doesn't come into the picture. Parliament does not come into the picture. It's a local High Court. Surely the CJI will be sounded and nobody will have an objection because it is the lightest of the exercises in extending justice. So you just have to just have a building, that's all. Honorable judges will travel there once in a while for a limited period in a year and then render justice, make the people of that particular region, Madurai or Port Blair or Jalpaiguri, feel good that they have easy access, proximal access to justice. And we have that Ladakh map, where we have the arrow marks from Leh to Jammu and Kargil to Srinagar. Yeah. So that's about making Sonam happy. Wish you all the best, and everything about the high courts and so on and so forth, you will find in this book as you would expect. Follow this book and you will be fine. God bless.